Good afternoon and welcome. First of all, I would like to thank Professor Harvey and his organizing team for inviting me to coordinate this second panel during the second day of the Michele Tarufo Girona Evidence Week. I'd like to apologize because we have no female representatives in this panel. We did want to have a female judge in this panel, but it wasn't possible. But we do have a regional diversity and ethnic diversity in this panel, whose members through their past, present, and future activities can contribute to this matter regarding the role of high courts in the dissemination and consolidation of the rules and decisions in terms of evidential legal reasoning. I think that we can start with our first speaker, the Lord Justice of the Court of Appeal of England and Wales, Sir Rabinder Singh. I think he's online. Lord Justice of the Court of Appeal of England and Wales.
Criminal Division. He practiced as a barrister from 1989 and became a Queen's Counsel in 2002, appearing in many cases in the appellate courts of the UK, European Court of Human Rights, and the Court of Justice of the European Union. He was appointed a Justice of the High Court in October 2011, a Lord Justice of Appeal in October 2017, and President of the Investigatory Powers Tribunal in September 2018. He retains links to academia. In the past, he has been a visiting professor at the LSE and a visiting fellow of Lady Margaret Hall, Oxford, and is currently an honorary professor at the University of Nottingham. Lord Justice Rabinder Singh, the word is yours, please.
The floor.
Thank you. I hope that you can hear me. I'm very sorry not to be able to join you in person in Girona, but sadly, this is a week in which I have to sit in the court here in London. But it's a pleasure to join you, even if only online. For the purpose of my presentation, I have a PowerPoint show, which I'm going to put on share screen now. So if you'll just bear with me for a moment, I hope that we will be able to get that up and running.
Yeah, it's okay.
Thank you. So I'm going to talk about issues of evidence in England and Wales, although for reasons I'll explain in a moment, I do have a judicial role in the United Kingdom more widely. I'm going to talk about my three roles. One is as a judge of the Court of Appeal Civil Division. Secondly, I will talk about my role as a judge of the Court of Appeal's Criminal Division. And thirdly and lastly, I will talk about my role as president of the Investigatory Powers Tribunal, I suspect that the tribunal will not be familiar to many lawyers or judges around the world. It is, unlike the Court of Appeal, which is the highest court in England and Wales, it is a tribunal which covers the whole of the UK. And so, unusually, I have sat as a judge in other parts of the UK, such as Edinburgh in Scotland and Belfast in Northern Ireland. So I'll come back to my role with the tribunal later. But let me begin with my role in the civil division. The civil procedure rules which govern appeals in this jurisdiction, in Part 52, make two things clear: that an appeal is not a rehearing of the first instance trial. The rules expressly state that every appeal will be limited to a review of the decision of the lower court. In other words, it's not a rehearing. And the second thing which is clear is that there are very limited grounds on which the Court of Appeal can interfere with the findings of fact made by the trial court. There are many cases in the highest courts in this country which make it clear that it is only if the court is satisfied that the first instance decision cannot reasonably be explained or justified on the evidence which was before the trial court, that the appellate court will be entitled to interfere with findings of fact. In many cases, the Court of Appeal has emphasized that the trial is not a dress rehearsal. It is the first and last night of the show. So it is incumbent on the parties to get their evidence sorted and adduce appropriate evidence as they think fit for the running of the trial. They should not regard an appeal as an opportunity to correct mistakes which they may have made when conducting their trial strategy at first instance. But that all said, there are circumstances in which the Court of Appeal can receive fresh evidence. In other words, evidence that was not before the trial court. This is expressly governed now by the civil procedure rules, but there is case law going back to the early 1950s, which we still rely upon. And essentially, there are three tests which are applied before we will receive fresh evidence. The first test is that the evidence could not have been obtained with reasonable diligence at the trial. The most obvious example of that would be where something has occurred since the trial, and so there simply would not have been evidence of it at the trial, but it can include evidence that was about facts which were present at the time of the trial, but which could not have been obtained with reasonable diligence at the trial stage. The second ground is that the evidence would probably have an important influence on the result. And the third test is that it must be apparently credible. So it's a fairly strict set of tests which we apply, but we do Not rarely, we do sometimes give leave to adduce fresh evidence at the appeal stage. I want to turn now to the second of my roles, which is as a judge of the criminal division of the Court of Appeal. And I want to emphasize the constitutional primacy of the jury verdict in the English and Welsh jurisdiction. Now, I'm aware that not every country by any means uses a jury of lay people, in other words, non-professional members of the public. In the most serious cases in England and Wales, where a crime is alleged, the trial court is known as the Crown Court. It actually hears only a very small percentage of criminal cases. It's about 3% of criminal cases. But they are, as you might expect, the most serious charges: murder, serious sex offences, serious drugs offences, and the like. And the starting point is that the role of the Court of Appeal is a very limited one when it comes to allowing an appeal against conviction. This is governed by Section 2 of the Criminal Appeal Act 1968. Essentially, the test is whether the conviction in the Crown Court is safe. So we apply a safety of conviction test. Sometimes the conviction will be unsafe because, for example, the trial judge failed to give the jury a proper direction about a matter of law. There may be other problems with the fairness of the trial process. But that's not the kind of case that I'm talking about in this context. What I'm talking about in this context is where an argument is made on appeal that the jury was simply wrong on the facts to convict the defendant. And this is where it's fundamental to our legal system that the jury verdict is considered to have a constitutional primacy. For example, in one case in 2012, the Lord Chief Justice, our most senior judge in the Court of Appeal, said that the constitutional primacy and public responsibility for the verdict rests not with the judge, nor indeed with the Court of Appeal, but with the jury. If, therefore, there is a case to answer, that is, after the prosecution have finished their evidence, there is a case for the defendant to answer, and after proper directions, the jury has convicted, it is not open to the Court of Appeal to set aside the verdict on the basis of some subjective judicial hunch that the conviction is or may be unsafe. It can therefore only be in the most exceptional circumstances that a conviction will be quashed on this ground alone, and even more exceptional if the attention of the court is confined to a re-examination of the material before the jury. So, understandably, sometimes people feel that the Court of Appeal is not sufficiently willing to interfere with convictions. There is a concern in some quarters that this may leave a miscarriage of justice uncorrected. But I repeat my fundamental starting point that this is because in our legal system, the jury verdict is considered to have a constitutional primacy. Now, again, in the criminal division, as in the civil division, it does sometimes happen that the defense wish to raise fresh evidence, and this can be admitted. In fact, it's probably more likely to be admitted in a criminal case, precisely because otherwise there is a risk of a miscarriage of justice. The rules on this are contained in Section 23 of the Criminal Appeal Act. And again, there are three tests which have to be applied. The first is that the evidence appears to be capable of belief. The second is that the evidence may afford a ground for allowing an appeal against conviction. And the third is that there is a reasonable explanation for failure to adduce the evidence at the trial. So again, the Court of Appeal is not there simply to conduct a trial again. We would not be in a position to do that, even if we wanted to, because we have no jury. We do not hear all of the evidence. But there is a provision for admitting fresh evidence, and it will be admitted if it is in the interest of justice to do so, particularly to avoid a miscarriage of justice. I want to turn now to the third and final topic I'm going to talk about, which is my role in the Investigatory Powers Tribunal. As I have mentioned, this is not confined to England and Wales, and does have jurisdiction in all parts of the United Kingdom. And the jurisdiction of the tribunal includes the following. It covers, for example, actions of public authorities such as covert surveillance, that's things like interception of communications, and computer network exploitation. This is a statutory phrase for what people commonly call hacking. And it, of course, concerns not only the intelligence services, it can include other public authorities, but an important point I should emphasize is that this tribunal has exclusive jurisdiction over any conduct of any of the intelligence services under the Human Rights Act. The Human Rights Act is the statute which incorporates the European Convention on Human Rights into the domestic law of the UK. And the intelligence services are the Internal Security Service, known as MI5, the Foreign Intelligence Service, which is known as the Secret Intelligence Service, or MI6, and also the intelligence gathering operation, which is known as GCHQ, or Government Communications Headquarters. Now, 30 years ago, when I was in practice at the bar, and I used to do some of these sorts of cases, the answer would have been really very simple. These things were essentially beyond the review jurisdiction of any court or tribunal. And when evidence was raised that national security would be harmed if these things had to be discussed in a court, then that was usually the end of the case. And there was no tribunal such as this which could go into closed evidence and examine the underlying national security evidence for itself. And that's all changed. The tribunal was created in the year 2000 and has brought into our jurisdiction various procedures which show the contrast with an ordinary court and perhaps illustrates the constraints and special pressures which can fall on the judicial system when it has to ensure a fair hearing, but without the normal processes which would apply to an ordinary court. And I'll just touch on some of those because of our special procedures. The Governing Act is the Regulation of Investigatory Powers Act 2000, which in Section 68 provides that subject to rules, the tribunal is entitled to determine its own procedure. The 2018 rules provide in Rule 13 that the tribunal may receive evidence in any form, including evidence that would not be admissible in a court of law. It may require witnesses to give evidence on oath, but no complainant, in other words, that's the individual citizen who makes a complaint against the intelligence services or other public authorities, no complainant shall be compelled to give evidence at the hearing. In fact, Rule 10 provides that the tribunal may, but need not hold a hearing. Now, in practice, we do hold hearings in the most important cases, but many of the cases are disposed of on the papers alone. The rules also provide that the tribunal must endeavor to hold a hearing in public and in the presence of the complainant. But where necessary, we hold a hearing in private. What that means is that the complainant and their representatives can be present, and on the other side, there will usually be representatives of the government. But the public, including the media, can be excluded. But, and this is the very unusual feature of a jurisdiction such as this tribunal, it can also sit in closed session. And what that means is that even the complainant and their representatives are excluded from the hearing. Now, how do we compensate for the apparent lack of fairness which that causes? The main way in which we do that is that Rule 12 provides that we can call on the assistance of counsel to the tribunal. These are independent lawyers who are security vetted so that they are permitted to see secret evidence, and they can appear at the closed hearing, they can ask questions of witnesses, and they can make submissions and will otherwise assist the tribunal. And frequently, what we ask counsel to the tribunal to do is to represent the interests of the complainant. In other words, make the points, ask the questions which the complainant would make if they had access to all of the national security evidence. Rule 7 of the rules provides the overriding duty on the tribunal is to secure that information is not disclosed contrary to the public interest, and this is particularly if it would be prejudicial to national security. So that brings me to the end of my 3 topics. In conclusion, I would like to thank you and simply say that I look forward to listening to the other members of the panel. And I will, of course, deal with any questions in due course if you have any. Thank you.
Thank you, Mr. Rabinder Singh, for your speak. It was very clear to us the competence of the Investigatory Powers Tribunal in England and Wales and all the United Kingdom. Agora eu vou
Now I would like to speak in Portuguese.
Justifico isso porque, primeiramente,
Well, this has been the language that has been chosen as one of the official languages, so I would like to greet Professor Jordi, and also because my Portuñol would not make it easy for me to convey the ideas I would like to share in Spanish, and because amongst the 172 people registered or in this second session, the second edition of the Michele Tarufo Evidence Week, we have 137 Brazilians. And this is indeed a very significant representation. That is why I would like to address the audience in Portuguese. I have prepared a presentation as well. And I would like to address the issue of the competence of the Superior Court of Justice or the High Court of Justice of Brazil. This is probably the court that has special powers afforded by the Constitution of the Federative Republic of Brazil. I would like to refer to the various processes that are usually addressed in this High Court, especially in the criminal chamber. And after that, I would like to talk about some cases that I believe are the most relevant ones when it comes to evidential reasoning and the influence that the court has exerted through its decisions on other courts and judges in Brazil. As you can see, its powers are broad, but what I would like to highlight is its actions in the ordinary proceeding and the so-called habeas corpus procedures. I'm referring to both the habeas corpus that is addressed by the court and also the habeas corpus that have been the object of an appeal. In addition to this, I would like to refer to extraordinary appeals as well. These refer to those appeals developing the main function of the court, which is precisely that of reviewing the decisions passed by the court, but not following the ordinary proceeding, but also to reread the case if there is a need in order to do their own tasks and to interpret the federal law. One of the duties of the Supreme Court of Brazil is to interpret federal law, as has been mentioned. The Supreme Court plays the role of a proactive court. It is precisely addressed to a jurisdiction on precedent that must be observed as background for other trials of the Supreme Court and other courts in Brazil. So this national law unit is carried out whenever they judge on special appeals, and I insist they are extraordinary appeals. They are subject to very demanding conditions, stringent review conditions, and thanks to this, a certain degree of stability in case law or jurisprudence is afforded. These review functions or duties, or the goal of the decisions passed by the Superior Court of Justice in Brazil, aim to mediate, to establish a mechanism of mediation as well between the various bodies, and thanks to this, they end up having an expectation as to what the legal consequences are and the conducts. This is really important in any kind of legal strategy. And this provides us with legal certainty and stability. Elements of key importance in any system where the rule of law is being implemented, of course. Now, I would like to refer as one of the main functions from the perspective of all of these instances to the production of material in equal footing. That is to guarantee equality before the law, and I'm referring to an equality that can be executed and apply through the judgment, through the processes, throughout the hearing, in terms of equality. And this must be the one corresponding to the various situations of facts and legal situations that will give a similar interpretation by the courts with respect to decisions that are made in the various instances. Nowadays, we can already see that we have the dominant perspective or view, which tells us that the role of the judge at any instance is not just that to declare the will of the legislator to constitute a legal constitutional rule. Those who interpret law, that is the judge, regardless of the jurisdiction, will carry out what is considered to be an activity that deserves fullness in relation to the interpretation of the text, and that is how we can apply and interpret the law to be applied in the very specific cases. And all of this, when this is done in judicial activity, grounded on the assumption of responsibilities and functions, and as an element that has been broadly affected and is seen as an activity of the court that is competent in order to precisely respect what the Constitution of the Republic requires in order to comply with the law. Thanks to this perspective, a framework is established as a source for law. So I would say that in Brazil, most of the law stems from the superior courts. Some laws were even voted and passed based on trials that went through, that were heard by the Supreme Court and the Federal Court, that has the capacity to legislate in a way that I would say can be used to interpret the law, accepting all hermeneutic processes so that ultimately the decisions can be made in the respective cases. I should also like to highlight the important role, according to Michele Tarufo. He already mentioned this in his concept of truth, of simple truth, and also in other papers and documents he produced. I mean, we can state that from his point of view, we are constantly seeing that there's an inclusive dialogue between the high courts. Nowadays, the globalized world makes it easier to build and create decisions, not just on the basis or grounded on the interpretation of the internal domestic law of each country. At present, courts, especially in Brazil, this is my opinion, make these decisions and produce them by consulting what stems from the decisions of other regional, international, and other superior or supreme courts. It's commonplace today for the decisions of the Supreme Court and also those of the High Court of Justice to be those of preference, or to base any other decisions through other decisions of other courts. Next, I would like to talk about the hyperatrophy of the Brazilian legal system. This is a system with more and more, ever more processes and judges. There are 27 courts of justice right now in the country, in addition to 6 regional courts, 6 federal regional courts. In total, some 18,000 judges. An astronomical amount of pending processes, more than 81 million procedures being followed in the Brazilian legal system right now. Also, in criminal justice, there are 39 million proceedings that are ongoing, and an amount that exceeds the actual ones that are being tried. This lists those that end up in this year. In 2024, as I said, there were 13 million new proceedings in Brazil, and 44 million are the ones that were tried. So we're talking about astronomical numbers, an amount of proceedings that is too excessive with respect to the resources that we have. Our system is lacking modernization with respect to the criminal proceedings in other parts of the world. The civil code is much more recent, but I would say it's a little bit more agile, but our criminal proceeding has been the same. Our criminal system has been the same for the last 80 years. I mean, there have been some updates, but with respect to resources available, we can state that there are big gaps. I should also note that we have some 20 different means to file appeals to decisions that are made. Some decisions can even be appealed more than once. I wouldn't like to bore you by listing them all, but trust me that this amount is absurd. The Habeas Corpus Institute, which is an instrument to protect common freedom, a deeply rooted tradition, it is the main element to protect the abuses that we have suffered throughout the various processes of criminal investigation. Well, one can base on the work carried out by this institute, and it is quite common to find in many cases, actually, there are two colleagues in the room, Judge Maria Teresa and Judge Sebastian Juan, who believe and know really well that there are times when when one case is judged or trialed up to 10 times, and the burden on the part of the court is significant. In addition to this 1 million habeas corpus cases, this figure was reached in April this year. The STJ, this court already has been going on for the last 36 years, and we have reached 1 million habeas corpus. Last year, we had 361,000 proceedings related with the special appeals. And for those who are unfamiliar with the Brazilian system, these are appeals against decisions of courts that, to a certain extent, could contradict the provisions of federal law, accounting for 71% of the proceedings of the STJ. Here, on this graph, we can see the historical evolution of habeas corpus. We can therefore see what the progression, the most dominant progression, has been like in recent years. In 2019, 500,000, and 6 years later, we have reached the milestone of 1 million. And this leads us to a quote from Michele Tarufo when he said, "It is necessary for courts to work less so that they can work better." It's humanly impossible for a judge from a high court of any court can judge the number of proceedings we are hearing or sitting without a sacrifice on the part of the justice system. That is, without sacrificing something or some of the elements of our system. We do whatever is possible to ensure due process, of course, but usually we have 12,000, 13,000 proceedings a year, and we have a large body of highly qualified staff, but the number is indeed concerning. On the other hand, this is not just our reality. This idea conveyed by Michele Tarufo with respect to the Court of Cassation of Italy, as we can see on screen, is quite revealing. The reality in Spain, in Italy, could be the same as ours. We'll see this later on. Here, I would like to address the second part of my presentation before I delve into more specific aspects that I would like to address later on. I believe that the issue of truth is always relevant. It's always important. And I must emphasize that I believe this is the value we must always try to attain from those who don't dissociate the concepts of truth and justice. It is not possible to have justice without truth. Father Antonio Vieira had an idea. Father Antonio Vieira had an idea which was as follows. He used to say, truth is the daughter of justice. And indeed, if I may allow to say so, I believe that justice depends on truth. And of course, in a criminal proceeding, based on other interests as well as other values and other rights that are likewise cherished, we see no room for the historical representation of facts through factual descriptions concerning the truthfulness or lack thereof of these facts in a free way. I believe we must respect and observe certain rules and standards from the point of view of epistemologically and the procedural view, but we also need to consider ethics and morality. This entails a sacrifice by the system, but these are milestones. Milestones need to be attained. We should not only base this on epistemological criteria, we must also count on some ethical foundation. Professor Perfecto Andres Ibáñez underscores very suitably that beyond the epistemical function of evidence, we must make sure that all stakeholders observe these rules with respect to any acts or events occurring legally. In our criminal jurisdiction, it has been crucial because the TSJ is comprised by 3 chambers: public law, private law, and criminal law. The latter, which is the one I belong to together with Sebastián Rejuna, is divided into 2 groups. And both groups try to decide on the habeas corpus. And when we analyze a situation of acknowledgement with respect to the nullity of a piece of evidence and we render it null and void, we do believe that we are nullifying the whole process, and in the end, the result will be absolution for someone who actually committed a crime. This is a sacrifice that needs to be made in the name of this implicit function in order to induce behaviors by the stakeholders that are addressing this task of conducting research, producing evidence, and also judging. Similarly, it is sought for criminals to be discovered and to use any evidence to this end. But it is also desired for the government not to stimulate other crimes to obtain evidence whenever there are other means available. I would rather have some criminals escaping justice rather than the government playing an undignified role. These are the words of Oliver Wendell Holmes. This was said in 1928. Another idea from William Blackstone and Voltaire are these: it's better for 10 people that are guilty to escape than 1 innocent suffers. I will talking about this matter next. But when we are sentencing or convicting an innocent party, we are making 2 big mistakes. One that is obviously impacting on that person, the convicted person, unfairly convicted, but we're also convicting society to coexist with someone who was guilty and was not punished. Now let me move on to the 3rd and final part of my presentation. We could even spend a long time addressing each of these aspects. Cases that have been heard at the TSJ and the High Federal Court, but to a certain extent, an issue of evidential law was discussed and also may be defined when gathering evidence to establish a rule of that action by a police officer or a member of the prosecution, and also when it comes to the assessment of evidence itself. That is from a judicial point of view. Here, I refer to all of these cases. We're talking about the habeas corpus 59886, dated 2020, in addition to habeas corpus ending 81, dated 2022, and running counter to jurisprudence, which up to said date had not nullified those processes where the only evidence produced to convict the accused had always been the acknowledgement or the recognition by the victim with respect to the accused or the accuser by means of photograph identification, but always in disagreement with the normative model, always in disagreement with what the Code of Criminal Procedure establishes. Said evidence, because of the impact of psychology and the mental state of the witness and also the rational evidence, could not be used. It could not be used to impose set set conviction. And Group 6 of the tribunal reviewed this process, and we nullified that process where the accused would have been convicted or sentenced only by means of this evidence without verifying other means of evidence that would have independently justified the option of final conviction. A second decision was that passed in March 2021, habeas corpus 598051. In this case, the decision of the Supreme Federal Court had already been passed, according to which the breaking and entering of a person belonging to the Republic could only be made during the day with a court order or in exceptional situations, such as when the crime was being committed at that moment, it being an urgent situation, so requiring the intervention of the police. Despite it all, unfortunately, this case law has not become consolidated, but we're talking about police practice where they access dwellings of people, usually residents of the most conflictive areas in urban cities, based on an anonymous tip. And this leads the officers to that dwelling. They are told that maybe they might find drugs or firearms, and for whatever reason, not always justified or explained, in the end the police officers end up accessing the dwelling, and they might indeed find drugs or firearms, without, though, complying with the court order and without valid consent from those inhabiting the dwelling. So I would say that the value of this trial was that it was stated that there was a need for a consent to be free, spontaneous, and valid, and that it could be verified that it was indeed valid. Because we can't always rely on the word of the police officers responsible for that operation. Those who are most interested, those with higher or greater bias, to confirm a narrative that ends up justifying access to a property, in this case a dwelling. So we decided that in the event of doubt with respect to a situation and with respect to authorization by the resident, then we would resolve any doubts as established in the system in favor of the guilty party or the accused. We are expecting the officers to have video cameras so that they can record what happened, both during authorization and also during the carrying out of the operation. By doing so, we could avoid all kinds of abuse that are commonplace when executing the act or accessing the home. It's quite common to see these situations occurring. When we're talking about some of them, they're even comical because they don't convey the actual truth. Just imagine, ladies and gentlemen, that there's a guy who is approached in the street who is smoking a joint, okay, and all of a sudden he is asked, where do you have more drugs? And he spontaneously says to the police with a gesture of friendship towards the officer, well, at my home, I have a lot more drug. I invite you to come to my place. They might even say the home address and the place where they hid the drugs. And the police always tells us this story, and we always believe them. It's not because a police officer cannot say or tell a story, right, like this, whether it's true or not. So I would say that there is a need that we have more control over the police. Whenever there are no video recordings, this evidence would be a determining factor to set any doubts aside. If we would have the recordings, we would, of course, remove any doubts and have a clear process, a robust process, and when we would know that we are actually convicting the author, the perpetrator of the crime. A lot of progress has been made following the habeas corpus 1588 50 to precisely ask that the police do not legitimate their behavior of approaching anyone in the middle of the street, as we say in Brazil, patching them and asking for control, putting their hands over their heads or behind their backs, opening their legs, kicking them in the middle of the street, you know? And we see these kinds of searches in the middle of the street. And there's a very low percentage that may lead to finding some object, such as drugs, but not in many cases. However, those who are searched in the middle of the street leave that situation without any kind of protection from the state. And police officers say, well, the person that we approached, or the police officer says, that person was showing a suspicious activity, suspicious behavior. But what is that? That person that was approached in the middle of the street is someone who lives in a marginal neighborhood, someone who doesn't dress properly, someone who is not wearing a t-shirt, or maybe he's wearing the Flamingo Football Club shirt. So the police officer just suspects that individual. He is suspicious of him. So that citizen ends up having under the authority of the officer because he wanted to search him. In the end, we can have much more rigor with respect to the testimony given by the officers, not because of lack of credibility, because the witness, the testimony of an officer is as valid as anyone else's, but we would have a much more justification to justify the behavior. Otherwise, they may even say there's abuse of authority. I mean, I would say that there is a need to build a narrative that is expected to be true, but from the point of view of the officer, knowing that in the future he will not be disturbed from a disciplinary or even criminal point of view. Now, let's talk about confession. Unfortunately, amongst us, I would say confession is the king of evidence. Many times we look for a confession to give more credibility. And in this trial, R1,193,6,996, especially RSP, notes 3234, the criteria to see what is the judicial perspective. The out-of-court procedure cannot be considered because out-of-court confession is done in broad daylight in front of a police officer with a firearm. There's no spontaneity. There is no even awareness on the part of the person confessing that they have rights, including remaining silent. And the last case is a decision that is still being developed at the TSJ. We already have a rather clear position, but the Supreme Federal Court still shows doubt, which is to establish evidential standards for the most important decisions in a criminal proceeding, not just the final decision to convict or not convict, but the right to make a pronouncement. Is an intermediate decision between the initiation of proceedings and the final proceeding for crimes that are the competition of crimes against life. As a result, we believe that this standard of proof and that this intermediate stage is not so much as what is required for admissibility to the person accused, but is not as strict or rigorous as what is required to convict could be. We're talking about a standard of proof that would be such as the triggering going evidence. So now to conclude, let me just share a couple of cases which I believe show what is happening in Brazilian criminal system.
Artigo ainda ontem de defensor público, Denis Sampaio.
We have an article that refers to Evidential, right? and it's a disruptive case law that has led to many changes in how we investigate and we assess the evidence. In this case, the case of Paulo Alberto, this is a tragic case that I faced for 12 years because he was judged in 2022 or 2023 in May. That's 2 years ago. And this young man, who was a concierge in the Rio area, and then suddenly there was a photograph in a police station, and he was subject to a lot of investigation and some with conviction, and he spent 3 years in law. And when the proceedings arrived at the TSJ through habeas corpus, and then we met in a session and we decided not just to grant the habeas corpus for that proceeding, but to extend it to all other proceedings to acquit Paulo Alberto. But the story didn't end there because we couldn't judge on many of the other proceedings, and he still has some ongoing proceedings, and he's still suffering due to this criminal process. And he has been, he lives in a nightmare. He hasn't been able to get rid of justice after spending 3 years in prison and 2 years in home prison. And here we have some of the quotes of some young people who are approached on the streets. That's why I mentioned the flamingo T-shirt before, because some young people say, I can't wear the T-shirt that I want to wear, and I cannot even run, for example, and that's my favorite sport. I have to leave home always wondering which documents I should carry, and I'm always afraid. And they are considered suspicious. And now lastly, I would like to refer to the case of a famous actress in our country, Thais Araujo. And here I would like to pay homage to Judge Santos Jr., who died last weekend, who would be fighting against injustice, in particular racial injustice. And she said when she became pregnant, she was happy to bear a son because he wouldn't have to face many of the situations that women have to face. But the problem is that my son is a black son, and therefore he won't be enjoying the same rights if he is wearing no shoes after a football or soccer lesson, and he may be considered a criminal because he's on the street and not wearing the regular outfit, for example. And if he goes to school on the bus wearing his school outfit, he may be considered a criminal in Brazil because it is the color of my son's skin that makes the perspective change, and his life, therefore, is going to be as hard as my daughter's life. And I like to end with one hope, the hope that there won't be any more people having this fear, the fear of Thais Araujo with regard to her children, that there are no more people who are subject to this injustice, to unfair investigations. There's a quote by Lord Jarrett, and he analyzed 250 unfair convictions, and out of the 250 cases, he said that this is just the tip of the iceberg. And we don't know how many Paulo Alberto cases exist in Brazil. We don't know how many young men face very abusive situations because of the color of their skin. And I would like to conclude by saying that here in Girona, we have had here this school, and we have many Brazilians here today because this school has changed greatly the way that we develop our criminal proceedings. Many books have been published, many courses have been organized that have to do with evidence. And now we have all these terms that are applied that have to do with credibility, with the value of evidence, the evidential likelihood. And this is often due to this school in Girona. Thank you.
Thank you. Agora, um momento. Professor. Agora eu passo a apresentar, e irá nos falar o professor.
I would now like to introduce Professor Mohamed Chande Othman.
Mr. Othman was Chief Justice of Tanzania 2010 and until 2017. In 2023, he served as a chairperson in the Presidential Commission on the Reform of the Criminal Justice System and Institution in Tanzania. Mr. Othman is currently chairperson as the United Nations Human Rights Council's International Independent Fact-Finding Mission on Sudan. He previously held positions as Prosecutor General in Timor-Leste and Chief of Prosecutions, International Criminal Tribunal for Rwanda, 1998 until 2000. You have the word.
Let me first begin by a word of appreciation for the organizers, Professor Carmen, Professor Jordi Ferrer, and of course on the prompting of our good friend, Professor Ron Allen, for the kind invitation for me to be here. I'm very glad to be part of this evidence movement. I will divide my presentation into three components. First one, I think it is important as a preface, I take you very briefly into three things. One, the court system in Tanzania, the legal system, the evidence regime, and legal precedents, because this is what we'll be talking about. But that will be very, very briefly. And then secondly part, I will deal with evidential legal precedents, but deal with only one aspect of evidence. And then thirdly, I will look into the impact of these precedents in terms of law and institutions. So briefly, the legal system in Tanzania has 4 hierarchies, and the highest court is the Court of Appeal, which is the final court that deals with all dispensation of justice. Below, it is a 58-year-old institution, but it was preceded before in the whole of East Africa by the East African Court of Appeal, 1960, and before that, the Eastern Africa Court of Appeal, 1902, which was also the appellate court for all the British protectorates, including Kenya, Uganda, Tanzania, Somalia, Aden, Mauritius, Seychelles, and so on. So as I said, the Court of Appeal is an appellate court and only deals with appellate proceedings, either coming from the second tier, which is the High Court, which is there in every region, and then you have also the specialized High Court divisions that deal with labor, family, economic crimes, land issues and so on, taxation and so on. And then at the third layer, you have regional courts. In each region in Tanzania, there are about 30 regions. And then you have district courts at the district level, 136 district courts. And then you have primary courts, about 1,000 primary courts in Tanzania. We don't have a jury system. At the primary court, also, you have magistrates who have an LLB degree and a postgraduate diploma in legal practice, about 5 years of legal education. So at the Court of Appeal level, as Justice Singh has mentioned here, the Court of Appeal is an appellate court, and it deals either appeals, first appeal from the High Court. High Court is the court that tries serious crimes like murder, treason, terrorist crimes, and so on. It is a first instance court for all constitutional interpretation. It is the High Court, and all appeals go there now to the Court of Appeals. This is briefly the hierarchical system because it is very important, I think, in terms of evidential evaluation at the Court of Appeal in terms of giving difference, for example, to concurrent findings of fact by the courts below. You don't look into that evidence and so on. I think the secondly is about the legal system. So we have statute law, which is mainly enacted by parliament. You have Islamic law, we have customary law, but we also have received laws during the colonial times and so on. We have them law, and also we apply common law and the doctrines of equity. But in terms of common law, and I want to share this dictum by Lord Denning, which says the common law cannot be applied in a foreign land without considerable qualification. Just as with the English oak, so with the English common law. You cannot transplant it to African continent and expect it to retain the tough character which it has in England. So common law, yes, but we don't apply it carte blanche in our jurisdiction. Thirdly, about the evidence. So our main legislation is the Evidence Act, 1967, which is modeled on the Indian Evidence Act of 1872, which is the work of an English jurist, Sir James Stephen, a 19th century jurist, of course, who relied a lot in terms of codifying common law into a code, and he relied a lot on Taylor's Digest, a treatise on the law of evidence, as administered in England. So it is mostly identical. The Indian evidence code is applied in many Commonwealth countries, in Singapore, which is the fastest growing economy, Pakistan, Sri Lanka, Malaysia, Singapore, Kenya, Nigeria, and so on. But it is not the exclusive source of evidentiary principles. There are many new laws, the DNA law, you have Electronic Transactions Act, you have Proceed of Crime Act, you have Tax Administration Act, and so on. So we have moved away from that. But the biggest debate that we have internally is whether to reform the law of evidence and to move away, to delink it from its heritage, which means really the heritage from its Indian connection, or to have a new code. And we have different kind of thinking. Professor William Twining, in Rethinking Evidence, thought that this Indian Evidence Act, our act, has withstood the test of time, and it has the clarity, but it has not prevented elephantiasis. We ourselves are more inclined to have a new code, and I share that view with Professor Lon Allen, who did also an independent study in terms of really the technical nature of our evidence law. There's a lot of litigation around the Evidence Act. Thirdly, I think part of our discussion here will center on legal precedent, evidential legal precedent, and their legal reasoning and their impact on law and institutions. So the doctrine of precedent, or stare decisis, is an integral part of the administrative justice in Tanzania, as in many other Commonwealth countries. And the rule is that wherever the courts, High Court or Court of Appeal, it is bound to follow its own decisions, but we are free to depart from them in both civil and criminal cases when it appears right to do so. Also, there are certain circumstances when a court can decline to follow its earlier decision, when it will lead to an unfair conviction, or where there are two conflicting decisions of the same weight, but there are certain principles in which to be that guide the court. So I think this is just a quick rundown on the system before I come to the main center of what I want to discuss here, which is really the question of evidential precedents and legal reasoning. So if you go to our judicial database, which is TANZLI, TANZLII, I checked this morning, there are about 102 judgments of the High Court and Court of Appeal. So it's very difficult to discern just the evidential reasoning which is there in any of these decisions. But I wanted just to deal with some aspects of precedent and evidential reasoning to connection with the discussion yesterday, which is about plea bargaining. It was mentioned here by Professor Rogerio about confession, and deal with a certain aspect of conventional evidence and legal precedent and reasoning, and how that its impact on law and on institutions. So in our system, there are three ways in which a confession is admissible. One is when a person comes before the court, he is charged and he pleads guilty. This happens for traffic offenses. Okay, traffic offenses, you are charged with whatever, over speeding, you plead guilty, and the proceeding continues. Secondly, is through plea bargain agreement, which we saw yesterday, the plea bargain agreement. But the third one is especially in very serious crimes, and I will deal with murder. It is when a suspect is interviewed by the police, and during the course of the interview, he volunteers a confession. So that is confessional evidence. It is taken into account, but there are certain rules. So our Evidence Act defines a confession. Okay, what is a confession? But the courts have developed that definition much further. So our precedent shows when that a conviction can be founded on a confession of a guilty accused. A confession before a police officer is admissible. In other Commonwealth jurisdictions, it is not admissible because of the risk. In India, it is not admissible. But in our jurisdiction, it is admissible. In some jurisdictions, it is admissible if it is before an officer of a certain rank. Okay, and then but we know from judicial experience, of course, that there are many innocent persons who have pleaded guilty, and there is a preference, of course, for the common law for an ounce, as what he said, an ounce of real evidence to an abundance of confessional statement. But our legislators also, given judicial experience and reasoning by the courts, High Court and the Court of Appeal, have looked into a revision of the criminal procedure, and now, in order to ensure guarantees, procedural guarantees, have included in our Criminal Procedure Act strict timetables for the interview of a suspect, that he has to be interviewed by the police within 4 hours of arrest. Otherwise, it is the head of a police station. Otherwise, then, after 8 hours, a magistrate in the 1,000 courts in the country is entitled, the police have to go to the magistrate to get the confession, to get the permission to interview this suspect. And there are a lot of procedural guarantees. As I say, our Evidence Act is also procedural, but it's also substantive in terms of some of the work. So case law has developed this further. So you have in confessions before police, admissible in evidence, mostly in trials, serious crime trials, like, for example, murder. And I take murder, for example, because not only is it a serious crime, but we have our courts process in a year about 1,000 murder or manslaughter cases a year. And the homicide rate in Tanzania is about 4% per 100,000. In Spain, I hear is 0.68. In South Africa, it is about 14%, and so on, and so forth. So what we do, the confessions before police, you have two kinds. You have those that are judicial and non-judicial, extrajudicial. Extrajudicial before the police, judicial before the magistrates. And everything before magistrates, there is judges' rules, which also apply in other Commonwealth countries in terms of what the judge should do, the magistrate should do in terms of admitting a confession. But our judicial precedence in terms of confession has also further developed, refined this, because even if you confess before the police, the trial has to be on merit. And it is a duty of the prosecution, has two burdens. First burden, beyond reasonable doubt, that the confession is voluntary and true. And the second burden is the burden of proof for the whole offense beyond reasonable doubt. So you have got two double burdens for the prosecution. So in terms, the case law, our case law and precedent and legal reasoning developed this categorization of confession into an additional category, which is what we call retracted confession and repudiated confession. Repudiated is when an accused person says, I did not make this confession. It is reduced in writing, it is presented to the court, but the accused, when he is before the court, he says, this is not mine. So he's denying that maybe his signature is not there and so on. So he denies having made the voluntary confession at all. Repudiated, he said, yes, I made it, but the content are not mine. The content are the content of the police. They are not my words. It's the words of the police. This is retracted. So case law and the reasoning behind the case law, and this is a judicial precedent that goes back to 1967, about 58 years ago. It's called Tuamoy, and the whole of East Africa, Kenya, Tanzania, and Uganda, it is the same position. So our courts have reasoned, saying yes, when a confession is contested, whether repudiated or retracted before a court, the court conducts a mini trial. It is called a trial within a trial to decide on the voluntariness or not, or repudiateness or not of that confession. If it passes that threshold, then it enters into evidence in the main case. Okay, it is not automatic, it enters into the main case and the case continues. So the court have warned that in this kind of situations where you have a retracted or repudiated confession, the court should proceed with caution. It is dangerous to act on such confession without corroboration, but corroboration as a matter of practice and not a matter of law. So if the court believes, and this is the language of the decisions, many decisions, and the decisions is very nuanced, so that it is not that the confession, if you believe the confession is true, you can act on it, you can act on it. It says you have to, the confession should be one in which the court finds that it cannot but be true. That means a certain level of certainty which is required. So there's still suspicion, I think, about this kind of evidences that confession and so on. But although, as I said, invariably in a lot of murder cases it is there. And one of the reasons we know why it is there is because when accused are arrested, sometimes they confess for whatever reason, psychological or remorse or contrition. When they go to pre-trial detention with other criminals, then they really change their mind. So when the case is tried, I think maybe 6 months, 1 year after the arrest of the accused, normally, invariably, I think in the cases I have tried when I was a High Court judge, they will contest this confession. But I say the courts have over the years developed, I would say, safeguards, warnings, safeguards, and in terms of the admissibility of this piece of evidence. And I think different jurisdictions, some say it is good evidence, it is sufficient evidence, and so on. I think the third aspect of my presentation, and I will conclude, is the impact of judicial precedents on laws and institutions. So the first really impact is that judicial decisions, precedents, reasoning of an evidence have prompted the police to rely less and less on confessional statements. I think you can see there is a trend that the police is looking to other evidence, additional evidence, not to rely solely on a confessional statement. Although the court can convict if it is free, voluntary, and it is definitely true and certainly true, but the police now look for other corroborating evidence and so forth, which I think it is a positive development. Secondly, judicial decisions have also prompted a revision of law reform, police law reform, including criminal procedure law reform. So now, for example, The criminal procedure, audio and video recording of interviews with suspects is a new legislation which requires this audio and video recording of interviews by suspects through specialized rooms, which are now being built with the support of the judiciary. I think the third impact really is the judicial pronouncements on evidential reasons and so on. Also have an influence on institutional reforms. And we are moving now from a police force to a police service. And this is mostly based again with the support of the judiciaries. But I think that for me I think a decisive question really is whether and to what extent legal judicial precedents and the evidential reasoning will influence a mindset change in law enforcement and its key stakeholders, because these institutions are extremely old institutions, inherited institutions, some of them as colonial rootings and so on. And therefore, how do you change really the mindset of those who are working in law enforcement to change from prison to correctional service? Because the criminal comes from society and is going back to society. So this is the kind of issue that I think that we try to focus really in terms of this mindset change through reform programs and so on. So I think just to conclude, as I said, there are many aspects of the law of evidence, and I wanted just to connect from yesterday's discussion about plea bargaining, but to speak specifically about retracted and repudiated confession, which is a species of confession. I think all admissions are not confessions, but all confessions are admission, which are admissible in court. But again, as I said, they are buffer checkpoints, judicial checkpoints, really before a confession can be acted upon safely before the courts. I thank you very much.
Thank you, Mr. Chande, for your conference. Now you give the word to Mr. Remo Caponi, that is judge at the Italian Supreme Court, former full professor of civil procedure at the University of Florence, Enrico Redenti Prize for Civil Procedure in 2022, member of the Presidium of the International Association of Procedural Law, founding member of the European Law Institute, member of ELI Executive Committee. He has 5 books and more than 200 papers in Italian, English, and German, and we will speak in English. The word is yours.
Thank you, Rogerio, for these kind words of introduction. Buenas tardes.
Good afternoon. Before I start, I truly regret not being able to speak Spanish. I am certain that I would be able, if I could share more time with this group of colleagues and friends, I would definitely learn Spanish very soon.
Let's switch to my poor English by first expressing my words of thanks to the organizer of the second Michele Tarufo Evidence Week at the University of Girona, and in particular to Professor Jordi Ferrer for kindly inviting me to participate in this panel alongside such distinguished colleagues who share their experience from 3 continents. accepting this invitation and preparing my presentation has offered me an opportunity to engage a little bit more closely with Jordi's remarkable body of work developed over more than 25 years now, I guess. His writings, as well as his editorial and institutional initiative, display for me an admirable blend of scholarly rigor and intellectual leadership. As you know, the topic of this panel lies exactly at the intersection of Michele Taruffo's main fields of inquiry: evidence, judicial reasoning, Supreme Courts, and last but not least, the pursuit of truth. By the way, this year marks the 50th anniversary of the publication of his groundbreaking monograph on judicial reasoning. I think we will have to celebrate this one way or another. Since I began preparing this presentation, Michele's work has remained a constant source of reference and inspiration for me, as the awareness of the unparalleled depth of his contribution. Now, I have been invited to speak in my current capacity as a judge of the Italian Supreme Court. However, I cannot overlook the fact that I served as a full professor of civil procedure at the University of Florence for nearly 30 years. And actually, I must confess, my vocation as a scholar was the first, is the enduring, and will be the last vocation. Now, you may well ask me, why did you leave the university? That's actually a good question. But actually, the answer arrived before the question. If you recall what Eduardo said this morning, and of course Michele as well, we need to see things from an outside perspective. And I choose, as it were, to make an experiment on myself, because the first thing we need to see from an outside perspective is ourselves, actually. Also as a scholar of civil procedure or philosophy of law or another topic. Now, based on my understanding of the scholar's vocation and my current experience on the bench, I view this was the first thing I learned sitting on the bench. These two distinct roles give rise, at least in my view, to two fundamentally different legal mindsets. By the way, I say this without implying any sense of superiority or of the one or of the other. This observation, by the way, leads to a comparison of the two perspectives, the scholarly and the judicial one, in order to assess whether they can be meaningfully integrated into a unified vision about this topic, but of evidential reasoning in the high courts, or another topic? Well, as I will argue, I don't think this is possible, actually, to integrate the two perspectives into a unified vision. In my view, their paths are ultimately bound to remain distinct. However, this divergence does not arise from an abstract dichotomy between theory and practice, but this perception arises from concrete experience, in this case, within the Italian legal system. By the way, I do not believe it is possible to trace a distinction between theory and practice. How can we trace this distinction? In my view, theory is simply a kind of practice. Without further ado, let's begin with my core presentation. My presentation will proceed according to the following structure. First, I will recall the constitutional provision. That's it, the Italian one. I will, of course, confine my observation to civil justice and the Italian Supreme Court's activity. I have a written version where I have a little bit broadened the perspective to the French system and the German one, but of course, I have to confine now myself to the Italian legal system. My presentation will proceed according to the following structure. First, I will recall the constitutional provision that significantly shapes the Italian Supreme Court functioning. As we will show by the most recent statistical data. Second, I will address the path of significant restriction in the Supreme Court ability to review the evidential reasoning of lower courts, a trajectory pursued by the legislator over the past, I would say, 13 years. Third, I will enrich this framework by drawing on my personal experience on the bench. Fourth, if I have time, I will offer a series of observations articulated as mentioned from the two different perspectives, scholarly and judicial one. And in the final part of my presentation, I will enumerate on realistic grounds 6 key points that define, at least in my view, the current feature of the Italian Supreme Court scrutiny of evidential reasoning. Now, let's begin with the first point, the constitutional framework. As you know, the Italian Constitution guaranteed the right to appeal to the Corte di Cassazione for violation of law. The Constitution ensures access to the Corte di Cassazione as a fundamental safeguard. As a consequence, the legal framework does not provide for a discretionary certiorari mechanism or preliminary screening phase to filter out cases considered minor or unmeritorious. Indeed, the most recent statistical report confirmed this fact. I brought the most recent statistical report. It covers civil proceedings between January and April this year. And it's a four-month period, and in this period, approximately 9,000 new civil cases were filed. 4 months, 9,000. In addition to this, the overall volume of pending civil cases is substantial. This problem, this structural constraint, given the constitutional framework, raises, of course, serious doubts about the court's current ability to perform the task of ensuring logical scrutiny of evidential reasoning conducted by lower courts. Such scrutiny demands depth, of course, depth and rigor, both of which are severely hindered by the workload we currently face at the court. Indeed, as I already mentioned, in terms of legal framework, compared to other jurisdictions such as Germany and France, I make reference to the written version of my paper, my presentation. The Italian Supreme Court has, over the past 13 years, initially followed a trajectory of significant restriction in its ability to review the legal reasoning carried out by lower courts with regard to evidence. A critical moment came with a legislative reform enacted in 2012, which substantially modified the provision of the Italian Code of Civil Procedure, which once served as ground for cassation for challenging lower courts' reasoning on the grounds of insufficient or contradictory statements of reason. This ground for cassation was narrowed to permit only claims of, quote, omitted examination of a decisive fact discussed by the parties. You can understand that under this revised formulation, by the way, was directly suggested by the then president of the courts. He went to a ministry with a piece of paper with the proposal of this new legal provision. And you can understand that under this revised formulation, claims relating to the internal logic, coherence of or sufficiency of the reasoning are no longer directly subject to scrutiny under this provision. And this shift was acknowledged in 2014 by two landmarks decisions of the joint section, Sezioni Unite, of the Corte di Cassazione. Nevertheless, a residual pathway for logical scrutiny was preserved through the general provision regulating the content of judicial decision, which stipulates that every decision must contain a concise statement of the facts and the reason for the decision. A violation of this duty resulting in reasoning that is missing, merely apparent, contradictory, or incomprehensible constitute along this provision, with this provision, general provision, a ground for cassation. Currently, this is at least my initial impression, the Corte di Cassazione is very cautiously broadening the scope of this form of review, reasoning is considered, quote, apparent, that is only formally present but lacking rational substance, when it consists of stereotyped assertion, tautological expression, or otherwise fails to meet the minimal threshold of rational intelligibility. The aim is, of course, not to reevaluate the facts, but to verify whether the lower court has articulated a coherent chain of reasoning that permits legal oversight. These developments, which are closely under observation by the literature, by the Italian literature, we have here some colleagues working precisely on this field, Salvatore Patti and Roberto Poli. I share Poli's point of view that the scrutiny over the evidentiary reasoning of lower courts is currently slowly regaining vitality, although through channels distinct from the classical ground for cassation. Now, I will speak now from my personal experience, a scholar on the bench, but remaining scholar in the first place. So I see from the distance, I see from the distance my current colleagues as well. I cannot. They say, we in the court. I cannot say we. I say the Corte di Cassazione. You know, keep distance. Keep distance from yourself, from your work as a scholar and as a judge. Now, in devoting my intellectual energy to scrutinizing the evidentiary reasoning carried out by lower court, in the case assigned to me first as a reporting judge, and then as a reporter to the panel, and then when I draft the decision, I face several practical constraint. These constraints arise, of course, primarily from the workload I'm expected to manage. Please keep attention. Like most judges at the court, I typically handle between 22 and 24 cases per month. This includes reviewing case files, analyzing legal issues, and preparing a preliminary report to support the panel's deliberation and decision-making. It also involves drafting between 22 and 24 fully reasoned decisions each and every month. Please note, we do not have a personal law clerk. We have some now addetti dell'ufficio del processo, but the law clerks, as it were, but they are working for the division. I'm on the second division for the division as a whole. They are not personal law clerks. No? I perform all of this work entirely on my own. Yeah, the problem are you can understand. The problem I'm facing with my legal mindset as a scholar. I had to switch. I had to switch my mindset in a way. the first problem is one must safeguard one's physical and mental health, avoiding an excessive sacrifice of private life and ensuring the effective enjoyment of the constitutional right to weekly rest and annual leave. Otherwise, you cannot perform your duty. Secondly, we need, and I personally, coming from academia, I have to strike a careful balance between the time required for preparing new assigned appeals and the time allocated to the timely drafting of decision already deliberated. And this evaluation demands great care. And now is a critical point. How can I perform this task? 22, 24 cases per month without clerk. I have come to regard, this is maybe the most critical point in my presentation. I have arrived to the conclusion that the distinction between question of fact as those questions that do not require the mental energy of a Supreme Court judge and question of law, those questions that do require mental energy, as nothing short of essential for professional survival. And I elaborated, by speaking from my experience, I don't think my current colleague would say the same, but seeing things from the distance. I kind of elaborated a form of relief mechanism in the exact anthropological sense used by Arnold Gehlen. Keyword is Entlastung, German. I could not manage this role as a human being, let alone as a judge, without such relief mechanism. And such mechanism allows me, as a reporting judge, to categorize the vast majority of cases as ones that do not require the full exercise of my mental energy. And these are cases that, at least at first impression, do not engage my mental energy. And I consider this case as rising purely question of fact, which, of course, by institutional design, fall exclusively within the judicial margin of appreciation of the lower courts. In the end, in the absence of an institutional screening mechanism, which in Italy we don't have, I had to build a kind of a personal screening mechanism. Of course, now comes the importance of the panel. But in the panel, this kind of relief mechanism can be, of course, corrected. If my colleagues say, no, this is a question of law, we discuss, and then I have absolutely no problem to change my first impression. This is also the panel, the five panel is I came really to appreciate the role of the panel. Many practitioners in Italian say, the reporting judge is the master. Then the panel has no role. It's not true. It's not true. In every of each case, the panel plays a very critical role. And however, you may now find this task of distinguishing between cases that require intellectual effort and the cases that do not, itself an intellectually demanding task. This distinction between operating this kind of relief mechanism is, of course, an intellectually demanding task. And given the sheer volume of appeals brought before the court and the number of cases assigned to each judge, it must be acknowledged that this activity, distinguishing question of fact from question of law, absorbs a significant portion, if not the majority, of a Supreme Court judge working time, at least in my experience. Now, there are two different perspectives on this situation. According to a first perspective, this is simply irrational. The fact that distinguishing question of fact from question of law consumes so much of a judge time contradicts the institutional mission of the Corte di Cassazione. Ideally, this function would require that the court's full intellectual focus concentrated on a limited number of carefully selected appeals. Therefore, some scholars, not that many, some scholars argued that the current system is irrational and should be corrected by introducing an institutional external screening mechanism, modifying the constitutional provision. As a legal scholar, I would continue to endorse this view. There is a pressing need I have written paper in the past. There is a pressing need in the interest of the Corte di Cassazione function and in the interest of the justice to introduce drawing inspiration from the, for me, in my view, from the German Code of Civil Procedure, to introduce an external screening mechanism modifying the constitutional provision. However, now, as a Supreme Court judge, I have in the meantime come to hold a different view. Why? On realistic grounds. If you were to ask me at this point what the chances are that such a reform will actually be adopted in Italy, I would answer they are virtually non-existent. Why? Because none of the relevant stakeholders has a real interest in promoting it. This is simply verdad, la semplice verità. The current states of affairs in Italy at the Corte di Cassazione, I would say, in the Hegelian sense, rational. It's rational, as you know. Hegel spoke of Wirklichkeit, not the mere Realität. The actual state of affairs is in Italy rational in the Hegelian sense because it is simply the product of the workings of the historical forces at play. Wirken, nicht Realität. Let's face it. Let's face. First, legal practitioners are keen to preserve unrestricted access to the Supreme Court. Second, most of my current colleagues they value their ability to exercise national level oversights over appellate decision. And this is from coming to the court for me, but was really an experience. Many of them value working under stress as a demonstration. They are simply the best jurists in Italy. I have the impression that some colleagues they wanted to have a screening, but most of them simply they like to work under stress. It's something crazy, but it is also, in my view, it's reality. Third fact: most scholars of civil procedure are also practitioners, and they too are inclined to defend this unlimited access to the court. And fourth, as a result, policymakers are reluctant to introduce any screening mechanism. Time flies. Therefore, on these realistic grounds, I will simply outline the six key points that define the current feature of the Italian Supreme Court scrutiny of evidential reasoning. Now, it will be an enumeration rather apodictic. I promise you, I will develop. I already developed these 6 points in my in the written paper. Now I cannot deliver a full-fledged argument on this point. So the six points, the apodictic points, are the following. First, of course, the distinction between question of fact and question of law remains at the core of the role played by the Italian Supreme Court. Second, the very act of drawing this distinction constitutes a question of law in its own right. That's like the question of distinguishing question of fact and question of law is a question of law or not. It's not a question of fact, it's a question of law. Then, if it is so, this first question of law, the task of distinguishing, is a kind of preliminary question and assumes a kind of primacy. It provides the foundation for assessing whether the case under review conforms or diverges from established precedent. Fourth, determining whether an issue concerns fact or law is a necessary precondition for the formation of precedent. Fifth, this distinction cannot be adequately drawn within a purely analytical or formalistic legal framework. Sixth, to discharge this task convincingly, the court must undertake a close examination of both the particular feature of the case and the reasoning adopted by the lower court in reaching its decision. As I already mentioned, I do not have time to develop a full-fledged argument to explaining and supporting this point. What I intended to suggest in the end is that if an appeal to the Corte di Cassazione is carefully drafted, and if we take seriously the logical impossibility of drawing a clear-cut distinction between question of fact and question of law, then the operative distinction will, in practice, rest on judicial policy consideration, namely on the kind of question the Supreme Court believes should or should not fall within its scope of review. However, five minutes, and I will conclude. I'm just in the final part of my presentation. However, these policy considerations are heavily conditioned by the workload that each reporting judge is typically required to manage. Here, I refer back to my earlier observation regarding the personal mental screening mechanism employed by the reporting judge. Some aspects of this argument will have to be, and I have just started developing in my paper, will be developed by engaging with important contribution made by Michele Taruffo on the distinction between universalism and particularism as two paradigms of judicial reasoning. In the meanwhile, but as a scholar, I was a supporter of kind of universalism. Now, I completely change. I completely changed my view. I am rather a supporter of kind of moderate, at least moderate, particularly, yeah? the close connection between law and fact. And of course, this argument might also benefit from an hermeneutic perspective. Let me conclude now with a quote by Anthony Poppy Jolowitz, which I have found in his book on civil procedure from 2000. I quote, for the purpose of comparative law, there is a little, if any, difference between the statements. On one side, the court may only entertain appeals on points of law, on the one side, and the statements, a point of law is a point which might be entertained by a court. We might not entertain appeals on points of fact. Quote end. If I had time, I would repeat slowly. But in a way, I like this thought by Jolowitz. I like from the perspective as a judge, because it's a kind of circular. It's a kind like the Ouroboros, the snake biting its own tails, and in the end, I find it I like this quote, this thought by Jolovis, because it encapsulates the core insight of my presentation. That is the significant margin of appreciation that arises precisely from the logical impossibility of articulating a distinction between question of fact and question of law. Now, if you don't like such kind of judge, you, and I speaking to my fellow colleague, judge, practitioners, scholar, they have to make pressure upon the legislator in order to introduce an institutional screening mechanism. Thank you for your attention.
Thank you, Justice Remo Caponi. It was very inquietant, your conference. Thank you very much. Agora vamos a ouvir o professor Dr. Ignacio Rodríguez Fernández.
And now, Dr. Rodríguez Fernández. He's got a PhD by the Autonomous University of Madrid. He is a prosecutor and career lawyer of the Constitutional Court of Spain, author of several monographies, including Demolition by Crime and Sacrificial Restrictions of Fundamental Rights. First one with Tomares, second one with Marcel Pons, also a member of the bills for the law, the prosecution, criminal prosecution law, 2011 and 2020. You've got the floor, Dr. Ignacio Rodríguez Fernández.
Okay.
Muchas gracias.
Thank you very much, and don't worry, I'm the last one. And normally it's good to be the last one to speak because you can listen to your colleagues' interventions. I was even able to digest my lunch, so not bad. Now, before discussing something which could be more arduous, which would be the powers of the Constitutional Court, generally speaking, in terms of evidence, I believe it would be more interesting for everyone and also lead to a more fruitful discussion if I try to focus on one of the problems of evidence reasoning that have been in the doctrine of the Constitutional Court in not a satisfactory way. The sufficiency judgment in relation with the evidence, so the core of the presumption of innocence. The Constitutional Court in Spain has a conception of presumption of innocence which is quite wide because it includes not just the judgment of sufficiency but also the problems of evidence procedure and basically the requirement that the evidence has to be gathered in contradiction, so an adversarial system with the parties, and also before the same court that will assess it in terms of giving a decision. And the reason for which the Constitutional Court has included these contents of evidence procedure in the presumption of innocence are probably historic ones. Before the coming into force of the Constitution in Spain, we had the criminal prosecution law, but criminal trials they proceeded in a very simple way. They started with the statement by the accused person and no further evidence was gathered. The documents were assumed to be reproduced, all the documents that have been requested during the investigation, and the hearing was just confronting the version of the accused person with the materials of the investigators. And normally they thought they were going to determine that the accused person was lying, so they were guilty. So they destroyed basically the presumption of innocence. It was similar to the confession with charges as known in the Inquisition, in the inquisitorial process. So basically tell us your version of the facts and we will confront it with the things we have accumulated against you. The thing is that the Constitutional Court in this situation, they found that no valid evidence had been gathered for a conviction because no evidence had been gathered with immediacy and contradiction, and there was lack of evidence. There was an insufficiency of the evidence. So there was an absolute insufficiency of evidence with a lack of follow-up of the evidence procedure. And so that was the historic reason, but these are two different things, actually, technically, because the lack of contradiction and immediacy in the gathering of the evidence basically creates the inadmissibility of the evidence, but not a further violation of the presumption of innocence unless the rest of the evidence gathered is indeed insufficient. So there is a flaw with the rest of the evidence gathered. So I will focus on this presumption of innocence in a genuine sense, although this contradictory doctrine historically in the Constitutional Court. The thing is that the constitutional reasonings leading to the Constitutional Court setting a system of presumption of innocence lead to a judgment of presumption of innocence which is dynamic, and I will try to explain why. The traditional insight that has prevailed in Spain, given the epistemological philosophy, is the understanding that the presumption of innocence has to do with the errors on the side of the accused person. We need to reconstruct the facts. It has to reach a degree of likelihood, and then in the hearing, this degree of likelihood of the thesis we are reconstructing, if it's a little higher than the contrary, that's sufficient. But when there is an asymmetry of interest, you need a higher degree of confirmation. Given that a person has their freedom at stake, there is an asymmetry, an absolute asymmetry between the accused person and the state on the other side, and therefore the highest possible degree of confirmation would be required. So we would have here a special standard of proof based on the idea that it is a guarantee for the freedom of the innocent. However, this traditional perspective is insufficient to the extent that in order to know whether there is an asymmetry, we need to measure the cost of the other side. And on the other side, the existence of incarceration doesn't always mean the highest degree of confirmation. For instance, if we are applying a measure because of a public health reason, the forced isolation of some person, which we don't know for sure whether they are diseased, but they have been in contact with someone who had an infectious disease. So we are lacking manifestations, symptoms of the disease, or scientific manifestations telling us whether this person is infected, but there's a suspicion, there's a reasonable doubt they might be infected. But in this case, the interest of the other side, the public interest of preventing the propagation of an infectious disease is so high that the reasonable doubt goes to the side of the public interest. So it's the opposite to what would happen with presumption of innocence in the criminal order. What's the reason for this special system in the criminal order? Well, the public interest applied in the criminal system is the enforcement of the penalty, of the punishment, and as the Constitutional Court says in Spain, the punishment does not meet a peremptory goal, but it is an additional evil to the compensation of the rights suffered by a person. So an additional given is given because it is needed for the social system to work, because you prevent the perpetration of new crimes. So what has to be taken into account from the constitutional perspective from the other side? From the side of the public interest, that there is an obvious asymmetry between a false positive, which would be the risk of convicting an innocent person, which would be instrumentalizing an innocent person, and another false positive, which would be not punishing a crime, which is serious, but more tolerable from a constitutional perspective. And that leads us to the third element to be measured. If we only had these two elements, we could reach a system of presumption of innocence, which would always be a standard in the highest possible degree. But the thing is that the fact is that what has to be measured from the perspective of public interest is the general functioning of the criminal system. We can't set an evidence standard and a standard of proof in which the criminal prosecution is not effective, and this explains cases the possibility of convicting someone with the single witness of the victim. In a system in which we only wanted certainty, we would not be able to convict based on the she said, he said, for instance, with of two parties with confronted stories. So this is like this because the criminal prosecution system does not, or is not able to reject this possibility, because that would amount to preventing the conviction of crimes committed in clandestine context, like in the household, or gender violence, sexual attacks. And therefore, from the perspective of the general functioning of the system, the single witness evidence is admitted as decisive, as an instrumental witness evidence, even if it's not corroborated, always, of course, assessing it. So these are the constitutional elements. How are they articulated in the case law of the Constitutional Court? Well, in my opinion, through three judges of sufficiency, we could call quantitative, qualitative, and material sufficiency. And this is a dynamic standard to the extent that what was a material sufficiency issue can become a qualitative sufficiency element. So the Constitutional Court in Spain said from the first decisions that the first thing that has to be done is to prove all the elements that are required to reach a conviction, so all the objective elements of the crime. So the facts and the participation. That does not mean that a lot of evidence is required, but that a single item of evidence, even if it's just one witness, has to verify all the elements. In the case of manslaughter, for instance, a single witness could be quantitatively enough if the witness saw someone killing someone, and if that person said, I killed you, I lost, of course, that will have another increase to the penalty, and all the elements have to be accredited. So the Constitutional Court of Spain has tried to identify this with very different offenses, but the most significant case for this new standard of quantitative sufficiency was the old crime in Spain of driving under the influence. The crime of driving under the influence was the influence of alcohol. However, in the criminal practice of courts, the practice had been imposed of condemning, convicting, if the alcohol test was above the maximum threshold. But the Constitutional Court that this was against the presumption of innocence, because what you're saying is that this person is driving with blood rate above what's allowed, but you're not really checking that this has an influence on the driving. There should be other symptoms like red eyes or an erratic behavior, halitosis, bad breath, something. That was a characteristic example for some times of quantitative sufficiency of the evidence. However, the fundamental issue in the case law of the Constitutional Court has been the identification of cases of qualitative sufficiency of the evidence. It is not about the evidence being complete, comprehensive only, but it should be reliable enough. And the way to assess the reliability of the evidence is to turn problems which are problems related to certain pieces of evidence to the general inadequacy of that evidence to produce the presumption of innocence. In the case law of the Constitutional Court, we find a number of very interesting cases. First, we've got the prototypical case of the co-criminal case. In the first phase of the case law of the Constitutional Court, they accept that the witness of the co-crime of the co-perpetrator could be enough to bring down the presumption of innocence and to result in a conviction if the credibility doubts are sorted out for that witness. It has some, you have some spurious goal. The prosecution has offered you something. You've got beef with the other co-perpetrator, the co-accused. This would be assessed, and also if the witness deposition is also done under oath or not. Although a friend of mine says it doesn't really care if in Spain witnesses lie, even if they are under oath, as a colleague at the Supreme Court. However, the transition from this material standard goes to the standard of the quality of the proof, as we could call it. That this transition happens when the Constitutional Court says that the problems with the co-accused witness deposition is so big that we cannot allow it
to sort out the litigation, and it is found inadequate to reach a conviction, and we require corroboration. That's a mandate for judges and for the investigators of the state, so that they will not settle for just a few little evidence. So also the Constitutional Court has considered, in terms of the reference witness, we see what are the problems actually when distinguishing the evidence procedure and the validity of the evidence and the sufficiency of the evidence. The reference witness is normally considered in all countries as a suspicious witness, as the Court of Human Rights says, and not very recommended because the direct source of knowledge is not subject to contradiction, which means it is only admissible following the European Court when the source cannot be accessed, and in that case it can be used as evidence. Surprisingly, the Constitutional Court, although they transposed this doctrine from the European Court of Human Rights, did not take the logical step. If it is a suspicious witness, which is uncertain, and exceptionally we consider it as admissible evidence, we should also believe there should be a rule for the quality of the proof, an insufficiency rule, rule to require corroboration, but they never took this step at the Constitutional Court. And this is opposed to the anonymous witness. In the case of the anonymous witness, the Spanish Constitutional Court does make a distinction between the requirements for admissibility. There is a problem of contradiction. We can't know who that person is, and therefore I cannot contradict whether they have something against me, they have some other reason, and this has to be made up for so that equity is reached. And the process is fair, we need also a high standard of likelihood for the conviction, and therefore it is required for that witness, for that anonymous witness, to be corroborated with other evidence. So a sufficiency rule is established here. In the current debate in Spain, to give you some context, the fundamental issue, as could be seen in the bills in 2011 and 2020 to reform the criminal prosecution law, is whether visual lineups also should have a rule for the qualitative sufficiency of the evidence. So there are some certain problems in the psychology of the witness and the visual identification of the perpetrator, and having just a lineup generates many odds of false positives and punishing innocent. So these lineups should be done in the right way. This happened to me 20 years ago. I don't know if this still happens, but when I was a prosecutor in Huelva in the south of Spain, I went to this lineup, and there were only 4, and they were just fill-ups, and the Spanish law says they have to have similar features, as makes sense. And I remember the recognition, the identification of the witness, and he said, this is not the guy because he doesn't look like him, and the other 2 are not because they are police officers. I saw them at the door. So, of course, this was useless. And in the case of these visual roundups, these visual lineups, they would have to be done in a serious way. And finally, we would have the last judgment of sufficiency, which would be material sufficiency of the evidence. Once we have reliable and comprehensive evidence, we have sufficient evidence in that specific case. We have ruled out all the doubts that an alternative hypothesis could be possible. In this case, the Constitutional Court acts differently. They act in the traditional plane of criticizing the evidence sufficiency. So if there's any doubt, they use the in dubio pro reo criterion, so they should not go against the accused person if there's any doubts. But then in the scope of the joint assessment of the evidence, they normally refer to beyond any reasonable doubt principle. So the requirement that there is a highest likelihood, the highest reasonable likelihood. But this is done in purely rhetorical terms, which are only technically specified in the case of circumstantial evidence. In the case of circumstantial evidence, the requirements placed by the Constitutional Court is that what is inferred from the criminal act, you need to find a logical reasoning based on principles that are sound enough, and that this logical reasoning is not excessively open. Well, when a logical reasoning is too open, it leads us to different conclusions, and therefore the defense doesn't have to do anything about it because the evidence just don't reach the standard of sufficiency because it creates reasonable doubt in an objective manner. A specific case, if you have in Spain, for instance, the crime of drug trafficking, just having on yourself drugs, if you're caught on the street with a certain dose of a certain drug, you need inference to reduce the evidence. If the amount is so low it is compatible with self-consumption, the inference that you are going to traffic with it is as likely as the hypothesis that you will take it yourself. So in this case, of course, this would lead to acquittal. Still, maybe searching this person would lead to finding other instruments, other tools that would determine the existence of a purpose of illegal drug trafficking. But beyond circumstantial evidence, there's no objective indication or objective standardization of the sufficiency judgment in its material sense. There are two requirements of different type, a formal or official one and an institutional one. The formal requirement by the Constitutional Court in Spain is that precise and comprehensive motivation has to be given to the evidence reasoning leading to the sufficiency of the evidence, which will lead to a conviction. And this is done in two directions: the existence of enough evidence and the non-existence of discharge evidence. So the defense evidence has to be presented, and also why it is not reliable enough. And then there's also the having two different possibilities of appeal in Spain following the orbit of the human rights and international law. We have the right of the convicted to a second instance, and we don't have a second prosecution. As my colleague said before, the appeal is not a new trial, so the actual trial is the investigation one, which is not a general rehearsal dressed with the costumes for the premiere. So there's the right to a revision by the accused, by the defendant, in such a way that if they are acquitted in first instance, they cannot be convicted in the second, but if they are convicted in the first instance, this new trial could lead to an acquittal. So they have two opportunities for acquittal and only one opportunity for conviction, which is in the first instance. And I'm always talking about evidence aspects and not the appraisal of the applicable law. This means that a double judicial conviction is needed, so that both instances will have to agree that the evidence given is enough to do away with the presumption of innocence. So in an actuarial system based on procedures and the intervention of professional judges, such as the Continental and the Spanish one more specifically, this is similar to the guarantee of the jury in the Anglo-Saxon system. The guarantee of the unanimity of the jury basically assures there's not going to be a conviction unless all the members of the jury agree on that. There is an institutional guarantee. In the US, for what I know, the standard of beyond reasonable doubt is not objectivized either. In some states, instructions cannot be given to the jury because they believe that the instruction of the judge will be instrumental for them to reach a verdict. But there is an institutional guarantee so that if the judge has left the jury to resolve because they believe the evidence is sufficient, then the guarantee of having material sufficient evidence beyond any reasonable doubt will mean unanimous agreement. In our system, we could this could be similar to the first instance judge and the appeal judge to believe acquittal is deemed. And this is just a history of the doctrine of the Constitutional Court in Spain in terms of the judgment of sufficiency of the evidence, which I thought was an interesting sample in terms of the evidence reasoning on the High Court. So thank you very much.
Gracias, Professor Ignacio.
Thank you, Professor. Moving on to the discussion. This could be by writing or orally. I will now give the floor to the first written question, or the first person who registered for asking a question. Professor Ferre? Mike is coming.
Muchas gracias. Gracias por todas sus aportaciones.
Thank you very much, everyone, for your contributions. Thank you to our 5 panelists. And as I said yesterday in the afternoon panel, Minister Rogerio Schietti, for the organization of this panel, particularly special acknowledgement to him. I believe that the topic of evidence reasoning or the facts in high courts is probably one of the myths that have to be debunked, one of those myths that cannot be sustained. I mean, sustaining that the facts are not relevant in the decisions or should not be the object of analysis in the decisions of high courts. Both constitutional courts, like the Spanish one, or Supreme Court, or high tribunals with the dual function, constitutional and legality control. So, at least for 4 or 5 reasons I would like to share. The first one is probably more relevant in the case of constitutionality control, and the myth is quite clearly expressed. Our legal procedures, the constitutional procedure laws, do not even foresee a mechanism to discover evidence on the facts in constitutional procedures. Why? Because the facts are meaningless, and they are meaningless because we are just judging constitutionality in an abstract manner, and we don't really need the evidence discovery phase. But how the hell do we do it to control constitutionality by indirect discrimination of a rule if no fact-check information is provided on the effects of such rule? And without that fact-check information discovered by the parties in the process, whatever they are, depending on the judicial order, where does the Constitutional Court get the information from? Well, often from just Googling or using ChatGPT, probably now. I mean, just to make it more trivial, but not using legally established procedures, because we don't have such mechanisms. And more specifically, in the case of evidence reasoning, not so much the evidence on the facts in those types of cases, but evidence reasoning as such in constitutional courts and Supreme Courts, there are at least 2 types of problems. The first one is the need for such courts to decide on the constitutionality or the interpretation according to the Constitution of the evidence rules in our system. Given that the facts are non-important, eventually the rules on the facts are non-important either, and for the purposes of constitutionality control. And I believe that's a very significant point. Ignacio Rodríguez was telling us about the doctrine of the Constitutional Court in Spain on some of these aspects, and I believe they go along that line of trying to design procedures and designing criteria that set out what are the constitutional guarantees of our evidential rules. But there are many other problems, even false problems created by the doctrine of our constitutional court. You are carefully pointing at some, but we could go beyond that. And then there is the need, and not just the need to control the rules we've got, but also the ones we don't have. So inconstitutionality by omission because of the lack of some evidence rules. I have sustained that the lack of properly defined standards of proof affects the due process, and if the due process is a constitutional guarantee, then we should also point to that. But yesterday we had this panel on plea bargaining translated into our systems, conformity sentences as we call them, or abridged procedures. And this is the huge black hole of guarantees in our systems. We've designed the Ferrari of guarantees for hearings, and then we locked it up in the garage, and we didn't design anything else. And this black hole is creating huge problems as well. So I believe there's a requirement. If we want to have constitutional safeguards in our procedures, we need the high courts to say something about these kind of issues. And then last, evidential criteria. Well, criteria to analyze evidence reasoning. It's not so much that high courts need to systematically reassess the evidence in specific cases, but because of problems with assessing the evidence in specific cases, I believe it is important to set these criteria. It's not just about being the second, third, fourth or fifth instance, depending on the design in each country, but at least setting up criteria. And this is something that has been abandoned to some extent in our countries, abandoned to the first instance judge, because that's why they were sovereign in matters of facts, or also because whatever there's a jury, they are sovereign in terms of rights. But we don't really set up the criteria. So I believe there is a long way ahead in some courts, more than others. Some of them are halfway or are making way in this path, but still there's a long way ahead in terms of evidence matters by our high courts. What we have seen this afternoon here is a really good example of how in 5 different jurisdictions, 5 different countries, they have tried to approach this issue. And I believe that's significant, but it would also be relevant to rethink these issues with regard to high courts. This is just a reflection, just a thought you can take in or ignore in your remarks. Thank you very much, Professor, for your very valuable remarks. Just a precision about this. In the constitutional law, there is actually an evidential procedure. But the thing is, there's no culture in the judges of the Constitutional Court to understand that this is very important, even in an abstract trial of constitutionality to gather evidence. In my practice in the Constitutional Court, we found cases of taxes on nuclear activities, for instance, and we didn't really understand what was the punishable problem because we didn't know anything. We didn't know the first thing about nuclear energy or what was being taxed there. And it would have made sense to have an expert witness there and to have had some kind of hearing. But there's no culture of using the evidence. But the basic law for the Constitutional Court is a good instrument to gather evidence. And some say that they never called for a hearing because the basic law gives you a 20-day deadline to give a decision only. But I don't think that's the reason. It's just the lack of a culture in which they place importance on actually judging the facts. I've got some written questions here. and also some oral questions. On my presentations and others, and I will try to add them up so that we don't run over the time we've got allotted. This is about to what extent the the Supreme Court of Justice has applied the precedents with binding effects, persuasive or not, or merely persuasive or binding of the former. There's also a question on the restriction to the determination of the facts done in high courts, whether reasons, justified motives should be introduced. And on these two, or to these two, I could add that the High Court of Justice, as a court assuming the functions of a court of appeal, presumes an action oriented to creating guidelines so that in the future they are observed in the court because they are some kind of horizontal authority of their decisions with regard to the members of the court themselves, or also setting precedents so that they are observed in further decisions in the future by other courts and judges. It is clear that in a country with 80,000 procedures, 18,000 judges in 27 state courts and 6 federal courts, it's not easy for these decisions to be complied with by all magistrates. And there's some resistance in some aspects, mostly in the criminal jurisdiction, because they have to do with ideology and different visions of the world. It's very difficult for a judge to accept that a traffic crime could be benefited, and that the accused of a defendant of a traffic drug, and that a prison penalty could be replaced by a substitution of rights, an open regime and not closed regime or incarcerated regime. So there's a reluctance by some judges, so that there is the magistrates have to be convinced. And in the Court of Justice, there is actually this very relevant conviction. And we've visited several courts in the country, and we've tried to disseminate this culture of observing the precedents. But again, this is cultural. And also this issue that Professor Jorge observed in terms of the limitations, cognitive limitations of the court. We need restrictions. This is not something that could work as Justice Singh mentioned. It is not a court to reassess the facts and to carry out a new trial on what the ordinary instances of the first instance judge said. There's a first instance court and the appeal court. So there's a factual base here that has to be well defined. And when the original court, the Court of Appeal, for instance, determines based on a factual, undisputable base where there's no divergence in terms of what happened, or an evidence factual material on which the judicial interpretation has stressed, we do this control. But there's a difficulty from the technical perspective of getting these judicial issues to the Supreme Courts in due time. In Brazil, we have a great deal of assumptions limiting this access to high courts, But again, mentioning public interest when in the examination of a process like a special appeal in one of the courts, we identify an interest, an issue with an interest which is above the individual interest of that part of the appeal applicant, we try to judge that appeal so that it is used as a means for which the High Court of Justice can exercise its main role, which is the classic function of uniformizing the law and the enforcement of the law and the uniform decisions of courts. So this is a continuous effort and a very significant one. And before moving on to more written questions, there have been some requests for oral questions. I will start with Dr. Vinicius Navaque. He's here.
To all the speakers, the presentations were excellent. I have two questions on specific to Sir Rabinder and general.
Okay.
My first question to Sir Rabinder is about the instructory powers. In Brazil, the civil procedure doctrine were majorly favorable to instructory powers, but their description about the infrequent use, and I know Germany and Italy have this notice too. My question is about the England has a common use of instructory powers. And minha questão geral para o painel é a respeito.
And then my general question to the panel goes along the line of Professor Ferrer on the reasoning of scientific facts that has gone increasingly to cassation or appeal courts, because in Brazil we've got this exceptional issue, but in any case, this is a debate that reaches higher courts around the constitutionality of scientific evidence. And these are sorted out before the court, considering the factual limitation of the court. And my concern is precisely how the court comes into the acceptance of these facts, basically, when they have a scientific deficit in that regard.
Justice Singh, do you hear us?
Yes, okay. Thank you. In response to the specific question that the last questioner asked about the position in relation to investigatory powers in the United Kingdom, the short answer is that there are such powers. They are regulated almost exclusively by legislation. Interestingly, the history is that before 1985, there was no legislation regulating even interception of telephone communications. There had been consideration given over many decades to having such a law, but it was felt by official investigations and inquiries not to be necessary. The first impetus for legislation in this arena came as the result of an adverse judgment from the European Court of Human Rights in 1984 in a case called Malone versus United Kingdom. And that criticized the UK at that time because there simply was no legislation governing interception of telephone communications, and therefore any interference with the rights in Article 8 of the ECHR was not, quote, in accordance with the law, unquote. So even before there was any question of balancing rights and proportionality, the United Kingdom's legal system at that time was regarded as deficient simply because there was no legislation, and therefore an interference with fundamental rights could not be regarded as being in accordance with the law. And so ever since then, in those 40 years since then, the UK Parliament has enacted a number of statutes, initially governing telephone interception, but more recently, there's a large statute in 2016 called the Investigatory Powers Act, and this covers a wide range of activities, including interference with computers. And essentially, the system, it requires there to be warrants before there can be such interference. And the 2016 Act requires there to be, in many situations, not only a warrant from the relevant government minister, but also, very importantly, it requires a judicial warrant from an independent judicial commissioner. And in most situations, that has to be in advance, although in urgent cases, that may have to be issued after the urgent situation has been dealt with. So I hope that helps to answer the question. Thank you.
Well, thank you, Lord Singh. Anyone would like to answer the second question? Because I think that our colleague, Vinicius Nabac, asked about the use of another kind of material in the constitutional judgments. Em Brasil, nós temos muitos processos nos tribunais superiores, tanto no Superior Tribunal de Justiça.
In Brazil, we have different instances, different courts, such as the High Court of Justice and the many described. With competition to consider the constitutionality or not, and we also receive contribution from other sciences or instances, not just through the processes through which even scientific material is presented to us that has helped us significantly in passing judgment. And this is a kind of evidence that has been very, very useful for us. So in recent years, this has been used with a certain frequency, and I'm referring to public hearings, something that has still not been done in criminal law. In the third session of the Supreme Court of Justice, we held a public hearing to listen to institutions and people who can contribute something so that we can address a process when it comes to the treating of cannabis for medicinal use, which in Brazil, according to legislation, would be a drug trafficking crime. But for those who require medical treatment, and for whom it has been verified that the use of cannabis has been recommended by several doctors, psychiatrists, or other healthcare professionals, this was a case in which two people were or had planted seeds for the future production of drugs being extracted from the leaf of the plants. So we organized this public hearing or public event. More than 40 institutions and NGOs attended, and other individuals as well. We listened to the factual and scientific contributions made by them, including doctors, and with that, we were able to judge a legal issue, which was to know whether the planting of cannabis plants constitutes a drug trafficking crime or trafficking for medical use as well. I mean, this was the object of another public hearing following the first session of the court on matters concerning public law and whether, as much as possible, we've accepted the contributions from other sciences. Law is not just limited to the mere interpretation of legal texts and the Constitution. Rather, it has opened up to contributions from other spheres in such a way that psychology, anthropology, or medicine can be considered or can contribute to a better federal or constitutional jurisdiction.
Yeah, just on the second point about the way in which a Supreme Court can be enriched with the scientific issues or scientific expertise. And I think at the highest appellate level, many Commonwealth jurisdictions, you have two windows. The first window is what was mentioned by Justice Singh about the introduction of fresh evidence. And that can be, there's a certain criteria for the acceptance of fresh evidence at the appellate court with certain guarantees. The second one is in relation to scientific opinion, which means that the court, in a number of jurisdictions like ours, you have amicus curiae, but amicus curiae, they are not parties to the proceedings. The court has to give them very specific questions. It can be scientific, it can be theological, if the case is dealing with constitutional issue of freedom of religion, and so on. So the amicus come to help the court in areas where they don't have expertise, but it rests really opinion evidence. It is evidence of opinion which a Supreme Court takes into account. So I think the court realizes the limitation in terms of expertise, and therefore you have these two possibilities. Thank you.
Bem, agora vou dar a palavra a...
I would like to give the floor to Mr. José Antonio Neira Flores now. I have several questions for several of you. I would like to start with Garcia. This panel is addressing evidential reasoning at the high courts. I understand that you made us the favor of providing us with information from high courts of justice. And there are 37. I would like to start by asking, what's the competence of the Supreme Court of the criminal chamber in Brazil, and how does it differ from the work that you carry out? Because I come from Peru, for instance. Our population is less than yours, with different courts of justice and plural instance in each high court of justice. Appellate court comprises the trial for the assessment of evidence and the factual examination. Extraordinarily, we have the cassation review stage when there are many different reasons. This will be a question also for the gentleman from Spain. The reasons for a cassation review or appeal are breach of constitutional rules, procedural rules, lack of motivation, and also breach of case law doctrine. So you said that in your country, the criminal procedural code has been in place for 80 years without any reforms. So I believe you are the only ones in Latin America who still continue with pre-investigation judges. All of us have had criminal reforms in Central America, in Latin America, even with the criminal procedural code for Latin America that was prepared by a great Brazilian jurist, together with Julio May, Fernando Larrua, Colombian Bernal. So I would like you to shed a little bit more light on this. I was also surprised when you referred to habeas corpus. So I don't understand. I mean, the criminal process, I mean, in addition to the criminal process, we have constitutional procedures too. One of them is the habeas corpus. But in criminal proceedings, if there is any breach to a constitutional rule, we have our own procedure. It's called defense of rights. And once we exhaust this proceeding in the criminal stage, if we consider any subsisting part in breach of this constitutional rule, we will start a constitutional proceeding. So please tell us, because we cannot access to the source of literature from yours. We speak Spanish, and we cannot gain access to your publications in your language. It would be great for the publication of Jordi Ferrer to be translated into Portuguese so that you can go straight to the source. We are lucky enough to read it in Spanish. And I would also like to ask a question to the Italian judge, because he did not say to us what the reasons for cassation are in civil and criminal law. He did refer to the workload, but in Peru, every week we have 31 cases a week. 31 a week times 4 is 124. Clearly, this is Latin America, it's not continental Europe. And I was telling that of the 100% of the cassations, 90% are declared inadmissible because they believe that it's the third instance. In the Supreme Court of Peru, criminal chamber, we focused on the facts as follows, not as a third instance, because if the article referring to control of the application of law, what if in a second instance judgment we see that the right to evidence has been breached? That is the rules of the evidence for a specific examination. What if there was an unlawful evidence obtained and it had been considered to convict, right? So then we analyze the correct application of law. And when we refer to defects in motivation or needs for motivation, what if a fact has been demonstrated with expertise that has no scientific input, or poor experience has been applied, or there are problems? In that case, we go straight to cassation. In the Supreme Court, we are well familiar with these cases, and this has to do with the facts. Obviously, we are not reassessing the evidence. However, the excellent presentation given by the attorney from the Constitutional Court referred to the Constitutional Court and the presumption of innocence. But I ask, does what you say differ from the motivation of the doctrine of the court, the criminal court in Spain, the second chamber of the Supreme Court? Because I imagine that in order for a case to be heard by you, the party might not have explained the motivation for the judgment of the second chamber to the court. And I may even go on to give an example which, despite there being a continental European pact already arrived at Latin America, such as the Falciani case, which was a case of unlawful evidence. May I try to answer the first part of your question?
In Brazil es muy...
I must say that the situation in Brazil is confusing. The Supreme Court is competent to ensure control of constitutionality. This is a control or supervision exerted by all OSs in Brazil. The Supreme Court supervises constitutionally matters, and in addition, they can judge people who hold top positions in the Republic. For instance, senators, MPs, and other positions as well. And they judge habeas corpus. When, for instance, the Supreme Court of Justice, my court, does not grant habeas corpus, then the party can gain access to the Supreme Court. This is an habeas corpus that is judged in the first level, in the first instance, then in the appellate court, Court of Justice, and then in the FTJ, the High Court of Justice, and lastly, before the Supreme Court, the Federal Court. So I believe that no country has such broad competence or authority in its jurisdiction. Citizens have the possibility of filing habeas corpus up to reaching the Supreme Court. And they control all the various steps along the way, including prison sentence. The jurisdiction of the court is broad, and it's difficult to implement uniformity in Brazil. I don't know whether this answers your question, but I would not say there is a clear division of powers. That is the High Court only federal, Supreme Court only constitutional matters. No, it's a little bit mixed up, if I may say so. That's why there are 80 million proceedings, and it's not a surprising consequence of the situation. And many proceedings are long-lasting as well. I think my colleagues will be able to answer the other questions.
Thank you for your question. In Italy, sorry for not having explained, but we have five grounds for cassation. The first one is about jurisdiction. The second one is about competence of venue problem. The third one is about violation of substantive law. The fourth is about the violation of procedural norm. And the fifth was it's the ground for cassation related with the reasoning, with the evidential reasoning performed by the lower court. It was exactly the ground of cassation that was modified in 2012. As far as, of course, I would confine my remarks to civil procedure. I'm not working on a criminal division. I would be restrain myself to civil proceeding. And of course, the problem you mentioned about the unlawfully obtained evidence would be under the number 4, so breach of procedural law. Now, I must confess, I don't believe it's very important to distinguish these 5 grounds for cassation. You know, it's in the German, it's all about theoretically violation of law, either substantive or procedural. The German CPO has only one ground for cassation. This is violation of law. Basta. And as far as the workload is, you told me I spoke about the workload. Yes, sure. This is for me a problem. Exactly before, there is no difference. I mean, the workload plays, at least for me, coming from academia, I must confess, it's a problem. And I cannot simply isolate the problem of dealing with the distinction between question of fact of question of law, it's not the same to discuss when you have 24 decisions to draft on my own. I have no assistance. I mean, this is a problem. So this plays a role or not? You mentioned you have 31 decisions per week. I would retire immediately. You know, I mean, yes, it's we have to keep a balance between the question and the workload. It's in the end it's a problem of proportionality of proportionality. I hope I some way answered your question.
Creo que me ha hecho dos preguntas, una relacionada con
Well, two questions were asked. One related to the reasons for cassation in Spain, the other about the relationship between the Supreme Court and the Constitutional Court. I will be short about this. I don't know about the reasons for cassation, and I'm really interested. I can tell you about the tendency in the Spanish law, which I believe is the right one. It is the following: there has to be a prosecution body, which is and this is the one that has to assess the evidence, and other has to review everything that has been done. This is the appeal body. In Spain, that would be the superior courts of justice, the province high court, and then the highest courts, the Supreme Court, come in, the Constitutional Court and the Supreme Court, but they have to see very few cases. These has to be cases chosen by the lower instances to sort out some problem which could help the judicial practice in general. It's not good to have 5, 4, 6 instances. We want a body to set uniform decisions so that everyone can follow and we can have a uniform practice throughout the system. And that's the trend with the cassational interest concept, determining that the Supreme Court can choose the affairs that can allow them in a jurisdiction to unify the doctrine in terms of material law or procedural law. And in the case of Constitutional Court, it would be particular constitutional transcendency. And in the case of the relationship between the Supreme Court and the Constitutional Court, we need to settle for what we are when no one is supreme. The Supreme Court has to accept there's a Constitutional Court, and sometimes they stand corrected, and the Constitutional Court also accepts there's the Court of Justice of the European Union or the Court of Human Rights. And the important thing is to have a judicial dialogue between all these bodies. And as for the relationship between the Constitutional Court and the Supreme Court, I believe that the usefulness of the Constitutional Court is not to forget they have this counter-majority character. They have to protect minorities. Their function should be distributing power so that the central state doesn't have absolute power, be it to protect the individual rights, is to protect minorities. And Supreme Courts often forget this vision. They have a composition with no merits of the public officers in the justice system, and they lose this political constitutional court. And in some cases, it is good to have this constitutional court protecting minorities against the majority constitutional interest to which the Supreme Court pays more attention. That's my vision. We have 2 more oral questions. I would ask you to be short and concise because we only have 7 minutes left. First, we've got Leandro Giannini. Thank you so much. I would like to go along the same line just exposed by the Spanish professor. It is true that the distribution between questions of law and fact has been dismissed often, and it is a good way to guide the function of Supreme Courts. But still, before this legitimacy and the methodological difficulties to control the function of the high courts, what you can do is say if there's no distinction, then everything should come in, but then the Supreme Court would collapse. It would make no sense because that's not what the Supreme Court is for, not only because they can't do that in practice, but also because we don't need them for that. But then you could just remove the judgment of fact through this discretional function in which the criterion would just focus on motivating the facts, and then they would extract that from the agenda of the Supreme Court, or maybe a medium, halfway solution, which would be designing filters to distinguish functions between transcendent and non-transcendent, relevant and non-relevant, with general impact and not general impact, with general interest and causation interest and not causation interest. So whatever is needed to guide the interest of Supreme Courts, and this could be issues related to the determination of the factic platform, often because sometimes determining the factic platform depends on the appraisal, on the assessment of how the evidence is assessed in every specific case, and sometimes the certain standards have to be determined to properly assess the evidence. So in some cases this can be useful, in some others not. Same thing happens with the questions of law. They sometimes have this contagious effect to know what the meaning of a rule is for the subsequent cases, and in some other cases the determination of a factic platform which has not been discussed to a specific subject of law, and sometimes whether this implies an abuse of law or serious label, or whatever could be a question of law, but that would be in the interest of the parties only. So this distinction, if we leave it aside, is not just to do the opposite, but to design a proper filter. If it doesn't matter whether they are questions of law or questions of facts, then we could have a filter so that we distinguish, we set apart relevant from non-relevant issues. I don't know if you agree on that. So let's hear the last question maybe, and then we can answer, we can get back to them jointly. Luca Martudano, is Gianluca Mantuano? Is he here? Yes. So my question is basically for the minister, and I'm going to discuss the situation in Brazil, which is the following. We have been seeing that most courts, as has been mentioned in your presentation, don't have so much impact, so much repercussion, as you said, particularly second-level courts, which, based on a hierarchy rationale within the Brazilian case law, should follow that model, and you have talked about that. However, we have the firm impression that even the courts themselves, the SDJ or the TSJ, have abode by their own jurisdiction in an infinite amount of cases depending on the case law. Therefore, there is an infinite amount of decisions and resolutions which are antagonistic and have completely opposed positions. Therefore, what are the pitfalls that we can find, particularly in higher courts and the Superior Court of Justice in Brazil? And the second question is about the following topic. You mentioned that there is an effect, and I'm going to read your words because I want to be precise here. You've talked about inducing behaviors given in other courts, and this derives from what I just said. Question: has there been any empirical research and empirical study proving that state and federal courts in Brazil have had or have not had any issue to comply with the requirements by the Superior Court of Justice? Thank you. Thank you very much for your question and for your clarifications and your being honest and brief at the same time. Of course, the complexity is huge in order to change a culture that has always been sustained on decisions that have always emanated from courts in general terms. And of course, they have always responded to questions of evidential law to gather evidence during all the expert evidence gathering process to bring about a change that was necessary. And this change was specifically in terms of the existing reluctances. And these reluctances are privileges of the judges, the prosecutors, and the ministers, even in my court and in the Federal Supreme Court. It's really sad for me to acknowledge this and to be a witness of this, which should be an advance for us to consolidate processes in a much more scientific perspective. It is sometimes complicated, and what we want is sometimes undone and cannot be executed. And what happens is that a reference is made to a previous case, and they say that case was better, and then as a judge I'm convinced with the evidence, and therefore it is really difficult to justify decisions. That's really frustrating, and we've had to cope with that. We've coped with this frustration and with the issues together with other colleagues, and we've tried to talk colleagues into making progress, because if we do not make progress, Brazil will keep on being a country where there will be a very high percentage of very authoritarian behaviors by all the elements in the criminal justice system, be it enforcement bodies, authorities of the civil authorities or prosecution authorities, and even the judges themselves. So if we're not able to raise awareness and see how public enforcement agents and public officers, if they're not able to implement this change, we will stay as always, as we saw in the cases I showed in my presentation. But still, we are hopeful for things to get better. I don't know if other members in the panel want to maybe answer the first question as well. Well, it's actually 6:30 already, and we could stay here for long discussing these issues, but I would just like to thank everyone here, Professor Carmen Vázquez, Professor Jordi Ferrer, of course, all of you for being here, and I would just ask you to come back tomorrow as expected, as scheduled in our agenda for this second Michele Tarufo